The first case that I'm going to talk to you about is the case of K&K from 2011. This is a Court of Appeal case and is a fairly well-known decision. The facts of this case involve a Canadian mother and a Polish father. They'd married and lived in England. Both were bankers and worked nearly full-time hours, but were both very involved in the lives of the children. The mother in this case applied for leave to remove the children to Canada, where her family were. She said she felt isolated in England and she was on medication for stress and depression. The father opposed the application on the basis that his support network and his family were in England and Poland. The CAFCAS officer in the case said that it was a very finely balanced case and suggested that in a few years' time, the children might benefit from a move, but not now. The judge at first instance took that recommendation to mean that the mother's application be adjourned, but nevertheless gave permission for her to relocate. The father appealed and was successful. There was a clear decision from the Court of Appeal that the case of Payne and Payne, which had previously been the key case on international relocation, was binding only in respect of one single legal principle, that the welfare of the children is paramount. The rest is guidance and indeed identifies helpful factors, but at its height, it is guidance. The Court of Appeal stated that this judge failed to give sufficient consideration to authority after the case of Payne, or the need to consider the particular facts of the case, and didn't put sufficient weight on the CAFCAS report. The two paragraphs you'll see on your screen are two paragraphs that I find quite helpful in summarising the current approach to international relocation. The second case I'm going to talk to you about is Re-F, which is a 2015 authority, again from the Court of Appeal. This case confirms that the case of K&K remains the current law and reiterates that the only principle from Payne and Payne that's binding is that the welfare of the child is the paramount consideration. In this case, there was a German mother who moved to England in the 1980s. After about 10 years in England, she began a relationship with the father. They married, they had a child. The father was Jewish. The mother had been Roman Catholic, but alleged during the proceedings that she'd been forced to convert to Judaism. So already there was an issue as to what this child's wishes and feelings were. It was noted in this case that the mother was very possessive and overprotective of the child. So it will be no surprise to hear that it was apparently very difficult for the father to agree the contact arrangements. The mother applied to relocate to Germany, giving as part of her reasons that the father didn't contribute financially. She was given permission to relocate, with a minimum of 6 weeks to be spent by the child with the father each year. The father appealed and was successful. The first instance judge was said to have focused too much on those Payne factors, with no clear identification of the welfare issues. And you'll see from the quote that I've put on the screen that it was very important that the judge hadn't considered the erosion in the quality of the relationship between the father and daughter if she moved, and there should have been an evaluation of the harm to the daughter of leave being refused as against the harm that would result from separation from her father should she move. So there's a clear steer there in the case law to consider both sides of this proposal. What if you stay and what if you go? This is from the same case. And again, we see here that the court encourages a holistic analysis and a holistic evaluation of both options. The court says each realistic option for the welfare of a child should be validly considered on its own internal merits, preventing one option from being sidelined in a linear analysis. That won't be the first time, well, it's not going to be the only time we hear the word holistic coming up in these cases. And Judge Ryder was very clear, a proposal that may have some but no particular merit on its own may still be better than the only other alternative, which is worse. A further well-known case is the case of Re-K from 2020. This is a more recent case, and I think the full judgment is well worth a read. The facts of this case are quite complex. Both parents were Indian citizens. They married in India, I believe. The father relocated to England in 2011, and in 2015, the mother followed him. Then the child was born in England and therefore was a British citizen. The family travelled together to India for a holiday in 2018. On this holiday, the father then removed the mother's passport and visa, as well as the child's passport, effectively stranding the mother in India, because without the father's consent, she couldn't obtain a further passport for the child. She returned to England, having to leave the child with her parents. The father started proceedings in India, the mother started proceedings in England. Eventually, an order was made that the child was habitually resident in England and should be returned. So on return to England, there was this hearing. The mother sought an order that the child lived in England and spent time with the father, but did say that if the court ordered that the child should return to India, then she would as well. The father sought an order that the child lived with him in India and spent time with the mother in both England and India. So Mr. Justice Williams confirmed that the only authentic principle in these relocation cases is that the welfare of the child is paramount. He highlighted the need for heightened scrutiny of proposals which interfere with the relationship between the child and the parents, and again made the point that the court has to complete a holistic and non-linear comparative evaluation of the plans proposed by each parent. Within his judgment, he summarised recent case law and put together, in his words, a composite for judges to consider when deciding these kinds of cases, and it's that which I'll take you to now. So this is the first section of the composite. We've got 3 more slides, which you'll be pleased to hear I'm not going to read out in full. But just focusing on point 3 on this slide, the judge sets out various factors in the welfare checklist, but then goes further and puts some proposed questions. How realistic is the plan in the sense that it's likely to be implemented as conceived? What will be the impact on the child moving permanently to another country when considering their relationship with the family that he's been left behind? Now, in my view, this question about how realistic a plan is a key focus for an international relocation final hearing. I'd expect this to be challenged from both sides on the actual ins and outs and day-to-day logistics that are being presented as the plan to move forward. The impact of the relationship with the left behind parent is obviously very important, and it's going to depend on each family how that might be affected. It'll be on a case-to-case basis how the court has to consider that. And as you'd expect, an older child will probably have more sophisticated means of staying in contact with their family versus a younger child. This is the second part of that composite, and you'll see the factors continue. Looking at the question about harm, the judge highlights what is the impact on the child on the change of their relationship with the left behind parent. What will be the impact on the removing party of having to remain in England, contrary to their wishes? And what will be the impact on the left behind parents of the child moving, amongst other questions? I think when preparing these cases, the evidence has got to be as clear as possible on what that impact is likely to be. And I would note that the court is going to be on the lookout for potential exaggeration on both sides of the argument. This is the final section of Mr. Justice Williams' composite with questions to be looked at. Taking the first point, he asks, is the application to relocate wholly or in part motivated by a desire to exclude or limit the left behind parent's role? Is the left behind parent's opposition to the move genuine, or is it motivated by some desire to control or some other malign motive? As I'm sure you'll be aware, motivation either to go or to stop someone going is a theme that often arises in these cases and would be something definitely to explore at a final hearing, no matter what side of the case you're on. I would say it's likely to be raised early once an application for relocation has been made. And again, the opposition to a move, is that genuine or is it controlling? I'm sure many parents who wish to relocate would consider that any form of opposition is controlling, but I would expect the court to explore that and an attempt to consider what the genuine motivation is on both sides. I would commend that judgment to you for a full read and particular consideration to this composite. The next case I'm looking at is the case of Re-H, which was a relatively local case before Judge Moradifer in Reading in 2019. The facts of this case are as follows. There was an English mother and a Dutch father. They met in West Africa and lived there together. And the children were born in England, spent a little bit of time in England, a little bit of time in the Netherlands, but their home was in West Africa with their parents. The relationship ended in about 2018, but the parents and the children remained living as a household. One day, the mother said she was taking the children to the beach. In fact, she took them to the airport and brought them back to England. Mediation was attempted, which wasn't successful. I think not surprising in the circumstances. The father then relocated himself to the Netherlands in mid-2019, and so this case came about. He applied to have the children living with him in the Netherlands. Now, somewhat unusually in these cases, which do start to become quite entrenched, the court noted that the parents agree that wherever the children live, it will be ideal that the other parent should relocate to live close to the children where they can be co-parented. I thought that was an interesting point that doesn't happen in a lot of these cases, but can the other parent relocate as well? That might be a further factor for the court to consider when assessing the options. Is there one location that might, on balance, suit both parents and the children better if the whole family is moving? In this particular case, the CAFCAS officer found that this was incredibly finely balanced and described both parents as exceptional parents and had no material concerns about either of them. She found herself unable to make a positive recommendation, thus it was left to Judge Moradifer to try and find the way forward. The second paragraph on your screen is towards the end of his judgment. You'll see he says, I find a lack of cogent evidence or justification for the court to interfere with the children's living arrangements. Accordingly, I dismissed the application for permission to relocate, and then he made a joint lives with order. So this is, I think, useful for both sides of a relocation argument. For applicants, it's clear that you've got to show that there is a positive benefit to the move to justify upsetting the existing arrangements, which seem to be working. It's not just that there's no harm that's being suffered, but that the children will be better off after the move. It's also helpful for respondents to try and frame their arguments in that sense. What is the justification to move a child who is otherwise doing well? The next case is the case of WS and KL, which is a 2020 case before Mrs. Justice Knowles in the High Court. So in this case, the mother was applying to relocate to Hong Kong. The final hearing was listed at the end of March 2020, which, as you may remember, was the start of lockdown in this country. So the decision was made to turn the case into a remote hearing, which at that point was a very rare thing. The final hearing was held remotely, therefore, at the end of March. Judgment was given at the beginning of April. Permission was given for this mother to relocate with the children, although it was noted that the mother was unlikely to be able to go immediately for obvious reasons. The father appealed. He had a variety of grounds of appeal, including the suggestion that the judge should have adjourned the final hearing rather than hold a video hearing. That point was, I think, sensibly withdrawn at the beginning of the appeal hearing. The meat of the father's grounds of appeal was that the judge had not undertaken that holistic and non-linear comparative evaluation, and that he'd failed to properly assess the disadvantages of the move and assess the risk of emotional harm. Now, the appeal judge agreed with the father, and his appeal was successful. The judge noted that there should have been this holistic evaluation, and that the judge in this case had not undertaken an analysis of the welfare factors relating to each of the options for the care of the two children. So it seems that the judge was aware of the requirement for this holistic evaluation, but didn't quite manage to satisfy the appeal court that they'd approached it in that sense. So when preparing for a final hearing in a relocation case, knowing that the judge has got to do this analysis of the welfare factors for each of the options, I would suggest that you make this as easy as possible for the judge, either in the statement or in the submissions or in a skeleton argument, by clearly setting out the welfare factors and giving a view from your client's perspective on the comparison of both plans on each of those. If you incorporate that structure into the proceedings from an early stage, then that will assist the judge to be answering the questions in the right way. The final case that I'm going to talk to you about is the case of Re A in 2021. This case involved a Slovakian father and an Algerian mother. They met in England. Their child was born in 2019. The father claimed that the mother had wrongfully retained the child in Slovakia and applied for her to return the child to England. The mother made an application to relocate with the child permanently to Slovakia. The mother had made allegations of domestic abuse that were found to be true, and in particular, the father had grabbed her arms, causing bruising, punched her to the chest, and threatened her with a knife. Now, despite those findings, the mother proposed that the father had monthly contact with the child in England if she moved to Slovakia, with more contact in Slovakia if he wished. The mother was successful. She was given permission to move, and contact was ordered as per her proposal. Father was unsurprisingly referred to a DAPP. Interestingly, in this case, the court was satisfied that this wasn't a father that would expose the child to a risk of harm. And the Kafkas view was that the child was not at risk from contact with the father, and it was reflected that he loved the child, and there was no evidence that he'd harmed her, despite the findings made towards the mother. There were concerns, though, that contact in any form provided potential opportunity for conflict and an attempt to control the mother. The real risk seemed to be that the father had no insight into his abusive behaviour. And it was seen that with the mother remaining in the country and that father's lack of insight, there would be significant detriment to the child if the mother were not permitted to relocate. And you'll see part of the judgment is on screen. The judge concluded there would be a risk of harm to the child were the mother to remain in England. In contrast, there would be significant benefits from allowing relocation to Slovakia, where her mother will be liberated from the worst aspects of the abusive relationship with the father and will have the loving support of her parents and wider family and community. I think it's almost certainly oversimplifying this to simply say, well, there was abuse proven, therefore she can relocate. But it's clearly a factor here that she's got the support of family and friends abroad. And there's particular concerns about whether the abuser recognises the impact of what they've done. So I think it's something to consider if you have a case with a crossover between the relocation and domestic abuse. Something which also appeared to carry a lot of weight in this case in particular is that the mother had promoted contact despite the history between her and the father. And it's recorded in the paragraph I've got on screen that the mother has honoured and facilitated contact to date in the most difficult of circumstances, and that boded well for future contact. Clearly, that was a plus point when the court was considering the mother's application and her proposals to relocate. And I think that's something to consider as early as possible in relocation cases. If the argument is that the relocating party is not promoting contact when the parties are in the same country, the court is obviously going to have to consider what is the impact going to be if they were miles away in a different jurisdiction without potentially the pressure of proceedings. So finally, I just want to talk about some practical tips for preparing for relocation final hearings. As you'll hopefully have gathered from the case law, this word holistic and the concept of non-linear analysis and the need to consider the welfare factors comparatively and properly sum up each option. All of that keeps cropping up. So as I've said, make it easy for the judge with your structure and how you're setting out the evidence in this case. Set out the welfare factors, give a view on the comparison, and try and have everything flowing from that structure. The composite that I've identified from Judge Williams is a very helpful way to guide your approach to the case. And I think probably he's already set out most of the questions that could be addressed helpfully in relocation cases. Undoubtedly, each case will have further questions that need to be addressed that are specific to the facts. But I think that composite is a very useful place to start with the argument, whether you're arguing for or against relocation, to start thinking about key issues and identifying strengths and weaknesses in this particular case. That final part of the composite addresses enforcement and mirror orders. Can conditions of contact be imposed in terms of provision of funds or frequency of visits? In lots of cases, parties will propose that they'll either fund the contact in future or that they'll make money available for the parent to be able to come back and forth, and for the child to be able to come back and forth. Put simply, if you're preparing a case where you say there is that money available, you need to show that there's evidence that that money is there and can be called upon. And I think that will take consideration of how that money can be held and accessed. Enforcement is also a key issue for the court when looking at these types of cases. If an order is made and they can relocate, can a mirror order be obtained? What's the recourse if contact doesn't work as anticipated? You may need to think in terms of obtaining evidence from a lawyer abroad as to the how it would operate in a different legal system, as to the existence of mirror orders, whether they are easy to get, what the costs of those might be. Evidence is obviously key in a relocation final hearing. I'm of the view that you can't have enough supporting evidence, definitely if you are making the case to relocate. And this may sound obvious, but I think it's very helpful to think through on behalf of your client the day-to-day routine and really what the ins and outs and the day-to-day logistics are going to be. Who's going to be doing the school runs? Is a school place confirmed? Have you got evidence of that? How does the educational provision compare to what the children have or would be expected to have in England? Is there a language barrier? How is that going to be managed? As much evidence as possible on all of these points is going to be helpful. What are the sources of support post-relocation? What are the sources of support in England at the moment? That's also quite a key point. And I think maps can be very helpful. And in one of the final hearings I've done recently, we had a map with where the family and friends were locally, which was helpful in identifying just who could be called upon and how it compared to the situation in England that had led to the application. You'll want to think early on about witnesses, people that can support the case, either for or against. Who would be the people that would be likely to be involved day to day if the application is successful? And if you're opposing, who are the people that are involved now? Who are the people whose relationship with the child is going to be impacted if they move abroad? Medical evidence might be something you want to consider as well. What are the, if a child has a particular medical condition, what are the options abroad? Or again, if you're opposing, what is the support or system in place in England that you're concerned wouldn't be able to be replicated? Travel is a key issue in relocation cases for obvious reasons. And in my view, it's going to be more persuasive in relation to travel and logistics if you can show a range of options for travel. For example, if you're wanting to show that flights are affordable, I think it's helpful to show a demonstration of flights. If you booked a flight a week from today, if you booked a flight a month from today, if you booked a flight 6 months in advance, how does that impact the cost? Travel time is also something that's sometimes easily fudged at a final hearing. A 2-hour flight is obviously not a 2-hour journey door to door. So you need to be realistic when making your arguments and taking into account getting to and fro the airport, the inevitable waiting around at the airport, and the impact of delays that may have. Accommodation abroad is also a factor to be considered. Where would the visiting parent be able to stay? Would they be able to stay with family? Would they want to stay with family? That is also useful to add to the picture. And finally, back up the assertions. Show me the money. if you are going to be supported by family funding, or that's what your client is saying, then you need to be able to demonstrate to the court that there is something to back that up. You need to be able to demonstrate that is a suitable solution and it meets the needs in the case. So thank you very much for joining me today. I hope that's been interesting. I think Simon will be sending around the slides afterwards, but please feel free to send me an email if anything I've said wasn't clear. Thank you very much.